just to support my colleagues' presentation, I wish to rely on the case of Odhiambo versus the Attorney General and two others, where the court pronounced itself that the court can intervene in matters victim protection to respect their rights and to safeguard their views. Your Honor, Section 9 of the Victim Protection Act guides this court to permit the views of a victim if the victim has been made sentiments in regard to them being processed through trial, because of the complainant that she is comfortable to go through a virtual trial because to give the views, and we wish to invite this court to consider these views. When you also look at Article 50(1) of the Constitution, every person has a right for his case to be resolved in a fair trial. Going down Article 50, sub-Article 9, that article states that Parliament shall enact legislation providing for the protection, rights and welfare of the victims. And that's why the Victim Protection Act came in, and it talks of all these presentations made before you are on behalf of the victim, and they emphasize that there is need for them to be taken through a fair trial. So we are making this application, let the concerns be adopted.
The list that my learned friends want to take court through this. If they are making their applications on the basis of the Victim Protection Act, and they're referring to Section 6, Section 7, Section 8, it's only to allow them to participate in the proceedings. We don't have a problem with that, and we are on record having requested their counsel for the victims to make that application so that the court can define the scope of the anticipation of the trial. However, Your Honor, that should not be the basis of the application they're making before the court. My learned friend appears with me in a civil matter, that is High Court Commercial Court number 23 of 2024. Between my client's company, another law firm, and they actually applied to be enjoined as interested party, and today as we speak, they are full parties defendants in that matter. Okay? So what they are talking about, the threat to her life, they have not given us any cogent evidence that there is such a threat. I'm hearing that from counsel. Would it not be better for him to take the stand, give the court cogent evidence on what he's saying about, what he's talking about? And in that case, it ceases being an advocate, he will be a witness. You know, the reason why you're being treated to this, which I didn't want to go into, is that on the 4th of April, actually on the 7th of January 2024, the so-called main witness left this country sneaking through the Kenyatta International Airport, where...
You know, that will now give us the evidence.
No, I'm giving you, if you allow them to give you hearsay evidence, Your Honor, I'm also an officer. I'm equally an officer of the court.
Also, I've not said you're not an officer, those are words into my mouth.
Yes.
You know, when we get into the main merits of the hearing, you've mentioned, you know why I'm not writing? I cannot rule anything, what is happening in the civil matter before the High Court. So that's why I'm not writing, because I'll just be adding, you know, pepper into, I'll be just putting pepper into pen. When you ask, okay, talk, speak.
It's becoming a little bit difficult to respond to these issues because you're saying you're not writing, they are made an
But what
application.
do you expect me to write about the High Court?
No, I'm giving you facts in response to the application.
Okay, so just
And if in good time, I'll be able to demonstrate to the court the relevance of the facts. If the court does not want to hear us on that, we'll keep quiet
No,
and we'll let the
I'm
court
writing.
proceed as it proceeds. It wants. We'll sit down.
Okay, speak.
Yes.
Okay, can you please in and out counsel? Don't be emotional in matters about clients. They come in and they leave every other day. But why I will not write about the High Court? Because I have no jurisdiction. And when a court has no jurisdiction, you put down your pen. Whether you mention matters in High Court, there's nothing I can do about it. Because I don't even know. It is you tell me.
Allow me.
Kindly, go
Allow
ahead.
me. What we are saying is that my landed friend and me are appearing in a matter in which the client, my client, are appearing. What decision are you supposed to make on that matter? What conclusion are we asking you to draw on that? What orders are we asking you to draw on that? Nothing. We are giving you facts. Then we can build our application and respond to this matter. I've not asked you to interfere with that. I would have forgotten my law if I'm going to ask the court to intervene in a matter that is in the High Court. I think I'm astute enough. I'm very much aware of the law as it is, and I will not bring something that is not beyond your jurisdiction. I was giving you facts, Your Honor. Basically facts. I'm saying that he is appearing there, I'm appearing there. We are not asking the court to make any orders or to make any conclusions on that particular basis, but we are building or to respond to the question that is before the court. If there is a particular manner that the court wishes that we proceed to deal with this matter, we are open for directions.
Your Honor, initially, when I was making an application, I had requested the court for the complainant to be admitted through an hybrid system so that she can confirm the sentiments of the advocates.
I can hear you. I think the only issue for the court to determine is for the hearing and how.
Yes.
Whether hybrid, physical, or virtual. And that is why I get to, all said and done. So can we come back to court for the virtual hearing on,
Your Honor, with your permission, what have you said about the virtual hearing? You have not responded to that.
you're on your seat, you sat down, so respond then.
Can we have some basic rules? If an application is made, we should be allowed to proceed. If that offends you, Your Honor, we should know.
What is that offending?
If us responding to the application made by the prosecution offends the court, we should
What
know.
is the response
Yes.
that you made?
I see now that the angle that you're taking, Your Honor, is like we are fighting. We are not fighting. I just want to
Counsel,
make a
you're
proper
putting too
response.
many words into my mouth.
Because
You've used the word offended. You've used the word.
are you offended?
Are you putting me on trial?
Not trying to put on trial. You're an officer of the court. I'm just also another officer of the court.
Are
If
you
you're
putting
being
on-
handled, handled in a manner that we feel that is not proper,
What is
We'll
it that
ask.
you're looking for? This matter was coming up for hearing, right?
yes,
Is it coming up for hearing?
it's coming up for hearing.
Is the court sitting?
The court is sitting.
Are you there for the accused person?
No, we are not the accused person. I'm not going to
Are
be
you
for
there
them.
for the accused person?
No,
Are you acting for the accused person?
no.
You are?
I'm acting, okay, you're confusing me because of this reason. Okay? Your Honor, there are two applications that have been made here that we need to respond to. One for adjournment. Two is how we proceed, whether it is virtual or not. I have my instructions. If you would allow me to present those views, then we make a decision. You are making a decision without hearing us. And I wanted to tell you, allow me to say this. The reason why that person cannot come to Kenya is because she's a wanted fugitive. And that's why I was taking you. The reason is there is a report made by my client seated here on the 7th of January 2024 against that person for stealing $2.8 million US. $2.8 million US. There's a complaint. I can produce the evidence so that there's a complaint against her. She was here. When she was here, she appeared and the IO is here. Who threatened her? They're not saying that my client is the one who is threatening her. They're not saying all those things. So theirs is to try and shield this person from facing the wrath of the law. We have this document to be produced. Will it be prudent and fair for us to have this document produced online? And secondly, I am not aware whether this person speaks Chinese exclusively and there will be requirement of a translator, which will again impede my client's access to justice. All these things must be taken into consideration. The last time we were before this honorable court, they indicated that she would be coming here. Now you're being told she has perceived threat. The threat that she's facing is of being arrested. It is dated 7th of January 2024. That's the threat that she's facing. And that's the police, not us. A complaint has been formally launched by my client related to the stealing of 1.8 million shillings that belongs to him or should have been paid to him and has not been paid. On the counter, she is making an... Excuse me.
I believe he should be tendering some evidence.
Yes, I can. I can.
Okay, listen, just a minute. Counsel, you said so many things. So, am I meant to be writing? I want to ask you. One, number two,
Yes.
what do you want me to do with all that information? Okay, allow me to read that what is before this court is conspiracy to commit a felony, contrary to section 393 of the penal code. The court is not aware of any other things, and that is I only have the purview of hearing this matter on count 1 and count 2. As to whether she's going to be arrested or not, I'm not Interpol. I cannot give those orders. It is not a matter before me, so I will not give directions onto that.
I'm not asking you to give directions.
So you are saying, that is what you are saying.
Let's do this. Let me make this proposal, my lady, with your kind
Go
permission.
ahead, go ahead.
Yes. Let
And
me make...
restrict your,
I will not
allow
say
me
more
to
than 10 words.
finish.
I will not say more than 10
Can
words.
I finish, counsel?
Yes.
Can you restrict yourself to this matter before court? It's file number E358 of 2024. As to whatever is before the High Court, as to whatever that she is to be arrested, allow me not to delve into that.
I will not go into that.
Yes. Because there's nothing I can do about that, and I do not have jurisdiction, because what I have is just this one particular matter, which is file number E358 of 2024.
Thank you. I will not go into those words.
Yes. So
Can I make that proposal?
let's not widen our nets. Allow me to just to deal with that particular matter.
Yes.
What is not before this court is not for me to hear.
No problem. Can you then allow me to make the proposal?
Who was on their feet before the other?
I was on.
You was on his
I was
feet.
responding.
But
Kindly.
we will get a just response.
Definitely you will.
Given the nature of the application by the prosecution and the victim's advocate, which requires evidence to be tendered before the court so that the court can make a informed decision, we pray that they make the application formally, we have an opportunity to respond, and then the court can give us a determination on how we can proceed.
Yes, and,
You know, based on that, that one can be done in 5 minutes. Just setting up the client wherever she is, she's admitted, she confirms her fears, and because it's like he's concatenating.
so can you set it up immediately?
Yes,
Go ahead. In the next 5 minutes.
Jonas,
Make a ruling.
can also
You
add
will
a
get-
bit.
thank you.
Jonas, as it's being set up,
Yes.
just want to clarify, council has talked about a report that was made in January 7. I want to confirm that the client was in this country in May. The client made the direct
That's what I was saying. I don't want to get into that.
She was not arrested.
No,
She
no,
made
I
a May
know,
now.
that's what I responded, counsel. Kindly, both of you. It's not a matter before this court. I do not want to get my head into other matters which is not. I believe the criminal justice system is at play in all what you two are saying. So let's allow them to do their work. But what is before me is E358 of 2024. As to whether even she's currently in the country or not, it is not for me to verify. What is before me is a hearing.
Okay.
And the only two issues, the person can appear virtually and the person can appear physically.
Yes, ma'am.
What you two are now asking is to set up, and she can now allay her fears,
Yes,
whatever she's perceived that she's not able. That's all I need to hear.
Yes,
Then I
ma'am.
make a decision.
most of like
I'm going.
which negotiable, but which next dispute?
806 of 2023. Silvan Sadoma? Silvas?